I'm very thrilled to be a speaker today here at one of the most well-attended industry chapters of the industry organization, which is AIDC. Thank you very much. Thank you to the chapter. Thanks to Gary and others. And of course, we will be talking today about contracts. And even before I start, I want to ask you to get engaged a little bit for me as a speaker. Can I please ask those of you who dealt with the contracts, and I mean dealt as negotiated, read them, had to probably manage them, to raise your hand? Mamma mia. Can I please ask those of you who negotiated and dealt with indemnity clauses in particular to raise your hands? Indemnity clauses? Great. I hope you will find this content useful. And for those of you, first of all, for those of you who I haven't had privilege of meeting and talking to, my name is Olga Labai, as I was introduced by Peter. But I am meeting constantly in this environment, especially at the chapter meetings. I'm constantly meeting people who are willing to improve and willing to improve their contracts and willing to improve the way their businesses work. And that's one of the ways. So, as Peter has mentioned, oil and gas consultants is 4 years old. We do a lot of contract-related work as we look at the procurement cycle, how terms and conditions get into procurement cycle, how procurement professionals are prepared with terms and conditions. Then I deal with product lines, I deal with businesses directly. So it's a lot of legal things for non-lawyers. One of my passions is LNG. So we provide a lot of training programs on LNG. And I need to tell you a little bit about myself. My oil and gas career started in Sakhalin 2 project. And that is a very interesting greenfield project, integrated. There are 3 offshore platforms. And hydrocarbons from those platforms from the north of Sakhalin Island flow into onshore processing facility. And then they go to the pipeline, which is 800 kilometer pipeline, oil pipeline and gas pipeline, and then they reach the state-of-art facility, which is LNG plant. And the LNG plant we had to build for Sakhalin is the first in Russia LNG plant. And on top of it, we had to create a specialized port in Russia. You can imagine how much fun lawyers and all the other business professionals had in this project. I then moved to Dubai and I joined Weatherford. I actually really wanted to know what is happening on the other side of the fence. What is in the contractors' minds when they come to negotiate with us operators? And as much fun it is to work for a contractor, it is also very obvious, at least for Weatherford, it was very obvious that the contract management function is often unattended. It's either absent or is spread to various experts and specialists in other fields. And I had to deal with product lines directly to ensure that that contract management or the lack of the contract management function is somehow compensated for. So what are we going to talk about today? I will briefly talk about risks to be covered in the contracts and about major industry disasters and their contribution to industry contractual practices. And as much as we would like to forget and we would like to not to consider and think about the events of 2010, which is Macondo, there are a lot of conclusions to be made on the legal and contractual side of things of that incident. I will summarize the incident for you, but not the way you know how it works, the whole circumstances, from the legal perspective, the legal aspects of it. And you will see how contracts have worked for some parties in the legal proceedings and haven't worked for other parties. I also will try to make a couple of recommendations, drafting tips for you so you have takeaways from the speech. And I absolutely welcome everyone to connect after the speech and express your opinion, what was interesting, what was not interesting, but there will be legal clauses. There will be legal clauses. Only 3, I promise, but we will have to read from the screen the legal clauses. That's how the whole core of this presentation will be delivered. So risk. There are categories of risk. We all know it. We all operate in a very uncertain environment. There are economic risks, there are political risks, operational as industry accidents and incidents happen. And of course, your clients, operators, very often they are operators. They think about resources availability. When somebody decides, or joint venture consortium decides to build the LNG plant, they have to sell LNG way before the plant will appear and way before FID is taken. And when they sell that LNG, which is virtual LNG yet, there is no LNG, but when they negotiate SPAs, they have to provide a certificate proving the reserves. So they think a lot about that. And that's one of the risks they're actually they have to deal with. Sorry, it's a separate click for each of these items. So we do know and we do see and we do deal with contracts that cover us from specific risk that is related to non-performance of one of the parties. The contracts we see, and we will focus our business minds on seeing how the contract reflects the specifics of the work performed. We also see the contracts that are covering your clients from the insufficient levels of quality. And of course, when you are the client, you will want to be covered from insufficient levels of quality. And there is an interesting risk that operators not very confidently addressing in their contracts is how to become less integrated. After contractors spend 3-4 years on site working with the company, there is a very big risk of becoming integrated into each other. So both organizations integrate into each other so much that the operator then, or your client then, does not see themselves in the future without you. That's the risk of overpaying for the services and goods. And of course, the contract has to cover all of the other risks that I've listed. But the question is how many of those risks and which of those risks actually need to be covered by the contract. My perfect idea of a great contract is that it is drafted individually. It is at least major contracts, but in my ideal world, all the contracts are looked at individually by a contract professional who connects dots and crosses the T's. So you have terms and conditions provided by one team, scope of work provided by another team, you have HEC requirements provided by a third team, you have all those components of the contracts. 95% of industry, of commercial contracts, in at least the ones I saw, a lot of them, are disconnected in a certain way. The scope of work is not uniformly applying the terminology in terms and conditions. The dangerous part of it is that you are relying your business decisions on the contracts like that. You are not just drafting them and they're there sitting. You are relying that they will work for you and they will be saving you from losses in the future. And every contract in drilling, in drilling activities, absolutely has to account for the incident that many of you do not even have to be reminded about the circumstances, but I will just voice it again. It's April 20th, 2010. The Deepwater Horizon mobile unit exploded. It killed 11 people and injured dozens of people and discharged millions of gallons of oil into the Gulf of Mexico, and the discharge lasted for 87 days. From the contract perspective, the relationship between BP and Transocean were governed by 1998 drilling contract. That's how I will call it. And this contract was initially signed by a different company, but it was assigned or novated to Transocean. The contract, as you will see here from me today, has the classic conservative risk allocation approach, which I believe works very well for the industry. And the idea of the speech was inspired by what Contracts Committee of the association is doing to actually empower you and to make sure that you are aware of what is that classic conservative risk allocation approach and how to steer your clients towards that and why we should not steer away. That's the basis of this presentation. So approximately 3,000 cases with over 100,000 named claimants have filed their cases in various courts in the US. And just to give you a flavor of what kind of claims they were. Claims including wrongful death and personal injury due to explosion and fire, obvious ones. Post-incident injury resulting from oil dispersants used in the cleanup activities, damage to property or natural resources, and economic losses resulting from the oil spill. That's the biggest amount of money that will be biggest claims for this incident. On August 10, 2010, all of them were consolidated in Louisiana District Court. Louisiana and Texas are two states that are trendsetters when it comes to lawmaking in oil and gas, just due to sheer history in the industry. But what you will see today is that the contracts created based on case law and based on principles and best practices in Louisiana and Texas cannot just be taken and copied into the contracts that are governed by English law and, God forbid, into the contracts governed by the UAE law. There will be completely different governance in those contracts. So the question in the legal proceedings that had to be covered extensively is to which extent BP had to indemnify Transocean for civil claims and the government claims. That's the mere question. BP said, yes, we have to indemnify Transocean, but they questioned the scope of that indemnity, how broad it should be. But that's the result of that question, or the answer to that question will identify the success or the loss of the whole legal process for one of the parties. So BP has, as I mentioned, admitted that they have indemnified Transocean for certain things, but they were challenging the scope of indemnity, and also they came up with the argument that the indemnity that they provided via that 1998 drilling contract is not compliant with the public policy. Should not be there. In basic words, is not compliant with law. And BP have tried several, we will see several arguments, but we will see what happened as a result of that. So let me just very quickly, very briefly, there are civil actions. Those are actions for personal injury, wrongful death, economic loss, property damage that were brought against Transocean. And in this process, Transocean and BP have cross claims against each other. And there are governmental claims. There are different ones. And here, United States have asserted claims for damages under Clean Water Act and the cleaning costs and the removal of damage under Oil Pollution Act. And both of the parties were named as defendants, and again they cross-claimed against each other, and there was a very complex, very multi-layered process. So how did Transocean get out of this whole story? And what the contract, 1998 drilling contract, says about the costs for incurred as a result of pollution. Legal clause, attention, attention, legal clause. Nobody's smiling. Legal clause, not today, please, not on Thursday. Yes, today and on Thursday. The contract, 1998 drilling contract, has contained this clause, 24.1. In my training, I have invented the method of how business people, non-lawyers with non-legal background, can read complex legal clauses, and they can be very, very, very hard to read. By the time I remember 17 years ago when I started, by the time I would read to the bottom of the clause, I would forget what's in the beginning. So this came to me when I was training for Energy Industry Council. There were a lot of clearly non-lawyers willing to get the knowledge. And the method is as follows, and it just came up to me. We tried and it worked. You delete the synonyms. Anything you think are the synonyms, you delete the whole array, you just leave one word. So hold, harmless, defend, indemnify are all or be responsible for are all synonyms. Leave just one word that you like, everything else you delete. So you basically, your clause looks like everything is deleted and there are only 3, 4, 5 words are left. You can get to the bottom of it very quickly and remember what it means. And lawyers use the same approach. We do have difficulties with reading those clauses. So essentially what will be remaining is this. So the clause, Transocean shall assume full responsibility, in other words, will indemnify BP for pollution or contamination originating on or above the surface of the land or water, without regard to negligence of any party or parties. In other words, anything that originates above the certain point, and that is a geographical principle of allocating responsibility and risk. Anything, you have seen the clauses with rotary table. Anything above the rotary table will be taken by contractor. Anything below is the same principle. Anything below will be taken by the operator. In this case, we have the geographical cutoff, the threshold, as the surface of the land or water, and anything above that is Transocean. Transocean says, I will indemnify any party, BP including, irrespective of their negligence, from any pollution originating above. What does that mean for an integrated drilling contractor? Loops, the liquids, pollutants, the small things and smaller scale pollution that can happen at the above point. What did the BP clause said? The BP indemnity said the following, 24.2. BP shall assume full responsibility for pollution or contamination, deleting the synonyms, don't read the synonyms, for pollution or contamination, including arising out of operations and not assumed by Transocean, which means anything below that threshold will be BP, anything above that threshold will be Transocean. And that is classic geographical allocation, classic allocation of risk based on geographical principle. The next clause, it is the last clause, I promise, I hear people sign, is the interpretation. The clause says the following. I will not force you to read it. You are already doing it. But this clause just talks about indemnity coverage. And it says, whenever the phrase shall protect, release, defend, indemnify is used, that means any type of negligence will be covered, including gross. You see the gross is highlighted. Meaning that any of the parties, when we provide indemnity to each other, that will be the very broad indemnity, including negligence, ordinary negligence, and gross negligence. So BP argued that those clauses, 3 clauses that saved hundreds of millions of dollars, billions of dollars, that those clauses were, as I mentioned, against the law or against the public policy in their case, and that they are happy to indemnify Transocean from the ordinary negligence, but hey, what happened over there was absolutely gross. And Transocean was grossly negligent. So that's the BP's argument. Transocean argument was very simple. Dear BP, dear juries, contract is clear, contract is very, very, very loud. We are responsible and be happy to be responsible for anything above the certain point, the surface of the land or the water. Everything below, not our responsibility. The court decided in this case that the wording of this clauses, of this provision, is very clear, conspicuous enough, vivid enough. There is a vividness test. I'll just talk about it in a second. And it clearly allocates indemnity, through indemnities, the responsibility for pollution to BP in here where it happened exactly in Macondo, and to Transocean where the pollution wasn't originating, or it didn't originate from there. Let me just step away from this case and talk about another one. In the US law, by the way, there is no US law, there is laws of Texas, laws of Louisiana, there is no UK law as well. Either the term is used colloquially or the person in front of you does not deal with contracts much. But there is no UK law, there is Irish law, Scottish law, and laws of England and Wales. Most of the time you use laws of England and Wales. However, there are a lot of wordings that come from the north of the UK, and they're influenced, Scottish law influenced. They have to, before you apply them to English law, they have to be looked, it's not the same legal system. There are different details, especially in the cases like that. So this case, Dresser Industries versus Page Petroleum, happened in 1993. And now a little bit to decompress you from the legal clauses, a little bit of animation. It was held in Texas Supreme Court. It was heard in Texas Supreme Court. And it is about conspicuousness. Something you, as known lawyers, would not even consider as a very big risk, as these guys didn't. So Dresser has a Page hired Dresser to drill the well. Dresser came and drilled the well. Some of their equipment got stuck. They asked Houston to perform the fishing. The fishing equipment got stuck, and they eventually lost the well. And when they lost the well, they started to look at the liability levels, and Dresser and Fisher said that they are not liable at all because there are indemnity provisions in their contracts protecting them from everything. So Page, it's your thing to do. They all went to legal proceedings, and the Texas Supreme Court established the following. Texas Supreme Court allocated the default, 50% with the operator, and then 40% with the Dresser, and 10% went to the fishing contractor. And the court said the following: if you don't make indemnity provisions vivid enough, conspicuous enough, 5 minutes left, oh my God, I know. Conspicuous enough and vivid enough, they will be invalidated in court. They are not standing still, and the court has basically allocated these percentages, and each party was liable. You have seen the US law influence contracts, or Texas or Louisiana influence contracts. You have seen contracts in which there is a big, bold underlining text. English law lawyers look at that and say, what is that? Why it has to be so vivid and bold and so different from other clauses? Because it's indemnity. And how lawyers and business people have defended them is to basically to make them vivid, bold, and underlined. So what do we see as a result of Macondo? I really need to make those conclusions. Is that operators, after what happened, operators started, and BP is leading that battle, started to challenge traditional risk allocation in the industry. The regulators also look at the major contractors thinking, why not them be responsible as well? Just have them in the pool of those being responsible for the incidents like Macondo. And I have read a lot of pages on that, and there is a very strong opinion coming from the North Sea, from the oil and gas legal experts, saying that this shift and the attempt to shift will create the risk for our industry to competitiveness and certainty of our industry. You have to stand still. You have to know what's the classic methods of risk allocation in the contract, what are the classic conservative indemnities, and how they should work, and you have to stand still. And again, your biggest supporter is the contracts committee of the association, who have a lot of information to share. So what I've noticed when I compared the indemnities, traditional and the ones that reflect Macondo, and I've compared them across hundreds of templates, is that most of the normal indemnity, I'm responsible for my people, you're responsible for yours, I'm responsible for my property, you're responsible for yours, most of them remain the same. However, it's the pollution where operators really try to ignite the change. This is the clause from the template by one major operator, and it's drilling MSA, and it basically reflects the new approach. And the new approach, oh, I promised not to show you the legal clauses, but that the new approach is the every party to the contract is responsible for pollution, but up to a certain cap. Guess what? You will have to get the insurance. It is igniting a change in the market that we are not necessarily ready for. This one I will skip. You're also in this, with this willingness to change things, with the willingness as the industry to stand still and to have better contracts that are conservative, for which you can insure your risks, for which you can absolutely be certain what is going to happen, you stand up against this. And this, your operators or your clients say, my terms and conditions are non-negotiable. Everybody else accepted them, and you have to accept them. Sign here, please. It doesn't matter these terms and conditions are terms and conditions for goods are given to a company that rents out the critical safety equipment, and the terms and conditions are at least irrelevant. You have to sign them. One just very quick bit of information for you in that sense as an ammunition. I have drafted a lot of templates of terms and conditions, the legal so-called part of the contract. These are the criteria, so categories in which I can draft them. If I'm Shell and I have the relationship with Iraq, and in that contract between me, Shell, and Iraqi government, there is a threshold of $250,000, as beyond which I will go to perform competitive tendering. Below that, I can single source and I can decide without tendering out. That is the threshold that is given to us, lawyers, to create terms and conditions for. So the terms and conditions then will be used irrespective whether it's a catering contractor, a minor construction work, or rental of the BOP, for example. It will be the same terms and conditions. Why? Because we lawyers have drafted them without any ability to know what will happen with those terms and conditions. We draft them 10 years before of the services that will be procured on those terms and conditions. So whenever you have the standard terms and conditions, it is by default not the right approach in the industry. There have to be some templates, absolutely, but how and when they are applied, it's a very far, what I see here and what I see in the industry is very far from my ideal of the perfect contract. The lawyers that draft them, together with procurement teams, cannot know what type of services will be procured with those terms and conditions. They do not know at which stage of the project it will be done. They do not know the length of the future contract. That's why you have a purchase order that was drafted as one-off purchase order given to you for 6 months supply contract. That's how industry operates. There is not effect on total cost of purchasing that is considered. Again, as lawyers and procurement sitting now 10 years before they will be used, we don't know. The experience with particular contractor is not considered, and any strategies, any supplier, any relationship with contractor supplier is not there. So to achieve and to streamline your contract practice, my big practical recommendation, and the one that I think will help any business to streamline those contract practices of theirs, is to create a contract risk allocation procedure. I recommend two: one for revenue generating contracts, one for procurement. It's where you, for your own business, for your own environment, identify what is my walk-away point. What is in the contract that I can't accept, or I can accept only with the board signing off? You will, through the creation of those procedures, learn a lot about what are the current circumstances in your contract practices. You will find out that there are a lot of battle of forms happening when you don't have an agreement on the terms and conditions. It's just the battle of forms. Clients send theirs, you send yours, and there was no agreement, battle of forms. Or you'll find out that a lot of clients have accidentally or willingly have already accepted your terms and conditions, and it's time to go and place proper MSA with them, just as an agreed set of terms and conditions. Why not? How much time do you have? No time. Ah, no time. Okay. Excellent. I wanted separately to talk about the insurance case, is where BP tried to get to the insurance pool of Transocean, but I'll speak about that. And one last thing that I will say is, please do not copy these clauses. They are not good for the contracts with which you work with in this region. I've seen that a lot. Oh, great clause. Let me copy it in, put it in my contract, and I've done my drafting. Well, these are the contract clauses that are based on a totally different legal system. First of all, you are in a totally different region, different laws applying to the contract, different laws to consider, and different circumstances to consider. So one of the practical recommendations is don't rely on these wordings. Thank you very much for listening and for your willingness to change.